judges of military tribunal.
This case is unusual in that the defendants are charged with crimes committed in the name of the law. These men, together with their deceased or fugitive colleagues, were the embodiment of what passed for justice in the Third Reich. Most of the defendants have served at various times as judges, as state prosecutors, and as officials of the Reich Ministry of Justice. All but one are professional jurists. They are well accustomed to courts and courtrooms, though their present role may be new to them. But a court is far more than a courtroom. It is a process and a spirit. It is the house of law. This the defendants know or must have known in times past. I doubt that they ever forgot it. Indeed, the root of the accusation in this case is that these men, leaders of the German judicial system, consciously and deliberately suppressed the law, engaged in an unholy masquerade of tyranny disguised as justice, and converted the German judicial system to an engine of despotism, conquest, pillage, and slaughter. The methods by which these crimes were committed may be novel in some respects, but the crimes themselves are not. They are as old as mankind, and their names are murder, torture, plunder, and others equally familiar. The victims of these crimes are countless and include nationals of practically every country in Europe. But because these crimes were committed in the name of the law and in the guise of legal process, the defendants and their colleagues distorted, perverted, and finally accomplished the complete overthrow of justice and law in Germany. They made the system of courts an integral part of dictatorship. They established and operated special tribunals obedient only to the political dictates of the Hitler regime. They abolished all semblance of judicial independence. They browbeat, bullied, and denied fundamental rights to those who came before the court. But the defendants are not now called to account for violating constitutional guarantees or withholding due process of law. On the contrary, the defendants are accused of participation in and responsibility for the killings, tortures, and other atrocities which resulted from, and which the defendants knew were an inevitable consequence of, the conduct of their offices as judges, prosecutors, and ministry officials. These men share with all the leaders of the Third Reich, diplomats, generals, party officials, industrialists, and others, responsibility for the Holocaust of death and misery which the Third Reich visited on the world and on Germany herself, was inimical to the ideology of the Third Reich. And it is not surprising that its principal authors recognized this fact at a very early date. We rose to power legally in order to gain the possibility of acting illegally. Later on in this case, the sage of Nazi jurisprudence, the late Dr. Hans Frank, summed this up aptly in 1934. National Socialism is the point of departure, the content, some of the steps which the law lords of the Third Reich took to turn the judicial system into a subservient but effective agent. The true purposes of this proceeding, therefore, are broader than the mere visiting of retribution on a few men for the death and suffering of many thousands. I have said that the defendant is the house of law, but it is, I fear, many years since any of the defendants have dwelt therein. Great as was their crime against those who died or suffered at their hands, their crime against Germany was even more shameful. They defiled the German temple of justice and delivered Germany into the dictatorship of the Third Reich.
Defendant Oswald Rothauer, on the count of the indictment on which you have been convicted, this tribunal sentences you to imprisonment for life. The marshal will remove this defendant from the court. Joseph Alstetter, on the count of the indictment on which you have been convicted, this tribunal sentences you to 5 years imprisonment. This military tribunal now stands adjourned without day.